All persons having business for this court, draw near, give attention, ye shall be heard. God save the United States, the state of Tennessee, and this honorable court. Criminal Court Judge Sandra Donaghby, Chancellor Casey Colbreth, and Chancellor Patricia Headmasker presiding.
Thank you, Ms. Spencer. Good afternoon and welcome to Davidson County Chancery Court, Part 1. We are here for a hearing in a three-judge panel case assigned by the Tennessee Supreme Court. I am Chancellor Pat Moskal. I serve the 20th Judicial District in Davidson County where this lawsuit was filed. Joining me on the panel are Judge Sandra Donaghby, serving the 10th Judicial District in Bradley, McMinn, Monroe, and Polk counties, and representing the Eastern Division of Tennessee. Chancellor Casey Colbreth serves the 25th Judicial District in Fayette, Hardeman, Lauderdale, McNairy, and Tipton County, and she represents the Western Division on this panel. Today is Friday, June the 6th, 2025. We are here at noon Central Time, or just a little after. The case that is called for hearing today is number 23-1196, Part 1. The updated style of the case is Allyson Phillips et al. Versus the state of Tennessee. We are live streaming today's hearing at the request of members of the public and through the AOC Tennessee Administrative Office of the Courts for the state of Tennessee on its 10 Courts YouTube channel. And I am going to ask now for counsel for the parties who are participating in today's hearing to introduce themselves. Who do we have present representing the plaintiffs?
Linda Goldstein for the plaintiffs, with Nicholas Cabot and Alexandra Willingham from the Center for Reproductive Rights, and Alex Lawrence from Morrison and Forster. And argument will be presented by Ms. Willingham today.
All right. And is Mr. Tift present? Your
Yes,
local counsel today?
Yes, Judge, I'm also here.
All right. Very good. Thank you. And representing the defendants, who do we have present?
Good afternoon, Your Honor. Stephen Griffin from the Office of the Tennessee Attorney General here on behalf of the defendants, and I'm joined today by Jenna Adamson from my office. And we also have a court reporter covering the hearing today who's on the call.
All right. Are there any preliminary matters that we need to address? Not hearing any. I will state that the purpose of today's hearing is defendant's motion to stay discovery pending a hearing on defendant's motion to dismiss and the plaintiff's response to that motion to stay discovery. We will hear from defendant's counsel first on your opening argument. We will then hear from plaintiff's counsel in response, and then defendants will have a short rebuttal. Are you ready to proceed, Mr. Griffin?
Yes, Your Honor.
All right, you may do so.
Thank you, Your Honor, and may it please the court. We're here today seeking a stay because discovery is proceeding in a case for which this court now clearly lacks subject matter jurisdiction. And in this case, Your Honors, the burdens of discovery fall on public servants. The plaintiffs have sued 2 state medical boards tasked with licensing physicians, the members of each of those boards, as well as the state attorney general. And so, Your Honors, we think it makes little sense to barrel forward with costly and time-consuming discovery in this case, when we believe that that discovery ultimately will prove to be a waste of the parties and the court's time and resources. The General Assembly just recently amended the abortion statute and its medical necessity exception that the plaintiffs have challenged here in this case. That amendment adds additional guidance for Tennessee physicians in applying that statute by adding definitions and also pulling from this court's temporary injunction order by giving examples of the sorts of serious medical conditions that would qualify for abortion under the medical necessity exception. The plaintiffs filed their operative complaint, the second amended complaint, on March the 12th, and state lawmakers adopted SB 1004, amending the abortion statute that they've challenged on April 17th. And so that same day that SB 1004 was adopted, we notified plaintiffs' counsel of the change in the law and gave them an opportunity to amend their complaint to address whether they believe that the new statute still contains any legal deficiencies and whether the new statute is actually causing them any harm, but they chose not to amend. And so we promptly filed a Rule 12 motion for judgment on the pleadings, arguing that this court lacks continuing jurisdiction over the claims set forth in the operative complaint. That's based on mootness of the right to life and the void for vagueness claims, lack of standing as to all claims, as well as sovereign immunity. We also pointed out that the operative complaint fails to state any plausible claim on the merits as it pertains to the current governing statute. The plaintiffs have told us in response that they can just present their new claims regarding the new statute through their expert reports. And if the state wants to learn about the facts that support their standing to challenge the new statute, then the state can just propound new discovery or take their depositions. But Your Honors, that's not how civil procedure in Tennessee works. And we haven't seen any authority from the plaintiffs or otherwise that would allow that sort of figure it out as we go type of approach. And at the Rule 12 stage, which is where we are today, it's the plaintiffs who have the burden to present sufficient factual allegations in their complaint that articulate a claim for relief that goes beyond the speculative level. And their operative complaint filed in March doesn't do that. All the arguments in our Rule 12 motion all turn on pure legal questions. And so no further discovery in this case would cure any of the deficiencies in plaintiff's operative complaint. And Your Honors, as we've noted in our briefs, courts routinely grant stays of discovery while considering Rule 12 motions, especially those that challenge the court's jurisdiction, and especially in the context of immunity. In fact, in federal court, when qualified immunity is raised, that often results in an automatic stay until that defense has been adjudicated. The plaintiff's opposition to our stay motion essentially boils down to just one point, and that's that the defenses that we've raised in our Rule 12 motion for judgment on the pleadings have already been addressed by the court in its prior order denying the motion to dismiss their first amended complaint. But Your Honor, as we've set forth in our reply brief, that's just simply not true. Since the court's prior ruling, the plaintiffs have amended their complaint. That includes adding a new plaintiff, adding a new claim, challenging the statute's mental health exclusion, and changing their request for relief in this case. And the claims that we've asserted in our Rule 12 motion all raise new defenses that have not yet been addressed by this court. The court has not yet addressed our arguments regarding mootness as to the plaintiff's void for vagueness or right to life claims. The original complaint attacked the statute based on lack of clarity. The amendment just adopted by the legislature adds new definitions, and pulling from the court's temporary injunction order adds a list of examples of serious conditions that would qualify. The mootness of the plaintiff's vagueness claim and their right to life claim has never been addressed by this court. The court also hasn't yet had an opportunity to address any of the plaintiff's standing to challenge the current statute. The court's prior order only addressed the patient plaintiffs and the physician plaintiffs standing to seek relief under the old statute, which obviously didn't have the definitions and example medical conditions that the statute now has today. And of course, the operative complaint contains no facts demonstrating that any plaintiff is seeking to obtain or provide a life-saving or health-saving abortion that would arguably be prohibited under the 2025 statute just adopted. There's also no facts in the operative complaint that address any threat of enforcement under the current statute against any plaintiff. And so the court has not yet had an opportunity to address the plaintiff's standing as to any of their claims under the current statute. The court also hasn't had an opportunity to address the standing of the new plaintiff, AMA, and that's because AMA wasn't in the lawsuit at the time of the court's prior ruling. We'd also just point out that the Tennessee Supreme Court has handed down new precedent since the court's prior ruling that raises even further questions, Your Honors, about the physician standing to bring a pre-enforcement challenge, as well as questions regarding the reach of associational standing under Tennessee state law. It was brought up in the previous status conference that, hey, we had already raised sovereign immunity. Why should we be talking about sovereign immunity again? But the court has not yet addressed the defendant's sovereign immunity in the context of the current statute. The only claims in the second amended complaint are brought under the Declaratory Judgment Act, which, as we've discussed, does not waive sovereign immunity. The court previously found a waiver under Section 13121, but the plaintiff's second amended complaint asserts no claims under Section 13121. And in fact, in the plaintiff's response to our motion to stay, they admit that 13121 does not create any cause of action regarding the constitutionality of a state statute. It only recognizes those types of causes of action, and they cite the Ross opinion as part of that admission. But, Your Honors, even if 13121 did waive sovereign immunity in this case, the plaintiffs can't satisfy it, and there's no exception under the Colonial Pipeline case that exists. It's now clear that the plaintiffs are not affected persons under the 2025 statute because they haven't alleged any desire to obtain or provide a medically necessary abortion that the 2025 statute would arguably prohibit. They also haven't shown any credible threat of enforcement by either the medical boards or the state attorney general against them under the current statute. The court hasn't addressed any of those arguments. And those are all arguments we've set out in our pending Rule 12 motion for judgment on the pleadings. And, like other issues that go to subject matter jurisdiction, sovereign immunity is a defense that can be raised at any time, including in the Rule 12 motion for judgment on the pleadings context. And the fact that the parties have already engaged in preliminary discovery doesn't change that. As we pointed out in our briefs, Your Honors, the plaintiffs could have amended their complaint to address how they think the current statute affects them directly, but they didn't, and we assume that they didn't do that because they can't. The court also hasn't considered the merits of the plaintiff's claims under the 2025 statute. The court hasn't considered the plaintiff's new equal protection claim challenging the exclusion of mental health conditions from the medical exception. And that's because when the court issued its prior order, the plaintiffs had not yet asserted a claim based on the mental health exclusion. And beyond that, no plaintiff in this case has alleged to even have a mental health condition that could potentially serve the basis for a medically necessary abortion. No physician has claimed a desire to provide an abortion based strictly on a mental health condition. Frankly, the mental health claim that the plaintiffs have asserted here is nothing more than an abstract grievance, just seeking an advisory opinion from the court. The fact that the defendants are all public servants just only amplifies the unfair prejudice that's caused by forcing the parties to continue discovery in this case. We've cited numerous opinions or courts have said that it'd be proper to stay discovery until a Rule 12 motion asserting immunity and other jurisdictional challenges has been decided. And Your Honor, the cost and time that discoveries are going to require in this case is already proven to be pretty extraordinary. The next thing on the calendar for us is June 25th is the defendant's expert disclosure deadline. Of course, we moved for a stay back in early May prior to the plaintiff's own expert deadline. But nonetheless, that's another thing on the calendar that's going to take up a lot of time and expense for the state. We've also been trying to confer with the plaintiffs regarding their deficient discovery responses. But we anticipate that we're going to have the court resolve a lot of those discovery disputes through motions to compel. We're currently processing thousands of documents and communications that we've collected from potential records custodians in response to the plaintiff's discovery requests. and are reviewing those for both responsiveness and privilege. We're also working with state agencies that the plaintiffs have subpoenaed for documents. That includes the Tennessee Governor's Office, the Tennessee General Assembly, and the Tennessee Department of Health, and we've already produced thousands of documents from the Governor's Office, but we're reviewing additional documents we've received in response to those. We've also raised objections based on legislative privilege, delivered process privilege, attorney-client privilege. We've also asserted objections based on relevance and burden. We think that those objections are especially amplified given the change in the law. And based on at least initial communications with plaintiffs' counsel, it looks like a lot of those discovery disputes are going to have to be resolved with the court through motions to compel. Once we have documents that we've requested from the plaintiffs, we also plan to request depositions, both the plaintiffs, potentially their medical providers, and their experts. So there's a ton of things left to do in discovery in this case. That's going to require a lot of time and resources, both for the state defendants and their counsel. The plaintiffs, on the other hand, haven't shown any urgency that would counsel the court against granting the short stay we've requested to give the court an opportunity to address the Rule 12 motion. And so, Your Honors, for all those reasons, the state is requesting that the court stay discovery until it has a chance to determine whether it still has continuing jurisdiction over the operative complaint, and whether any justiciable or plausible claims remain in this case. Happy to answer any questions.
I have one question, or at least one question. We have an April 27th, 2026 trial date, and this is a 3-judge panel case. And as I'm sure you can appreciate, with the number of lawyers and the number of judges that are involved, we scheduled that date, and it is on the 3-judge panel's docket. You have outlined a lot of discovery and a lot of work that needs to be done in this case between now and April 27th. And I am not prejudging your motion to dismiss, but with the volume of work that needs to be done, it seems to the court, and my question to you is, if we stay discovery, it's just going to make it more difficult on the parties to press ahead with the discovery that is needed and present some time pressures. What is your response to that?
Well, the top line response, Your Honor, is that there should be no discovery in a case for which this court has no jurisdiction. And so any discovery taken in this case,
But we don't, that is almost prejudging the motion to dismiss, and until there's a ruling on the motion to dismiss, whatever discovery needs to be done in the interim would seem to be prudent to press ahead so that we don't get further behind on our scheduling.
And Your Honor, there's a lot of cases that have held that it was proper for the trial court to stay discovery upon the mere assertion through a dispositive motion of jurisdictional challenges like we have here.
And that's discretionary with the court, correct?
It is discretionary, and Your Honors, we believe that it would be an abuse of the court's discretion to require the parties to go forward given the current posture of the case and the change of the law. We think that the court.
And you're saying it would be an abuse of our discretion,
Your Honor,
for us to go forward. Is that your position?
Your Honor, we don't think the court can ignore the fact that the law that the plaintiffs have challenged has changed, and
Would you answer my question first, and then you can explain it? Is it your position that this panel would be abusing its discretion were it to deny your present motion to stay discovery?
Your Honor, we think it would be an abuse of discretion given the fact that the law has changed, that the current complaint makes absolutely no mention of the current law or how that law affects the plaintiffs, that we would be required to conduct discovery without this court ever even determining whether it has jurisdiction over the claims asserted on that discovery. The Tennessee Rules of Civil Procedure say that the plaintiff can't seek discovery if they haven't asserted a claim that supports that discovery. There's no claims in the complaint that address the new statute. So of course the trial date would have to be moved, because if a stay is granted, there's plenty. If the court denies this, the motion for judgment on the pleadings, of course, we've raised jurisdictional challenges, including sovereign immunity. We think there would be an opportunity for that to be resolved through the appellate process. But nonetheless, Your Honors, if the court does stay discovery for the short period of time it needs to resolve the Rule 12 motion, we do think that the trial date would have to be moved. But at the same time, we don't think the court can go forward under the current scheduling order anyway, given the change in the law.
Let me turn to Judge Donaghy and ask if you have any questions for General Griffin.
The last question really addressed what was on my mind. Being able to proceed to trial in April if the motion to dismiss is not favorable to the state. And I think I've got the answer to that.
All right. Chancellor Colbreth, do you have any questions for General Griffin?
Not at this time.
All right. We'll give you an opportunity to speak on rebuttal.
Thank you, Your Honor.
I'm happy to hear from plaintiff's counsel now.
Good afternoon, and may it please the court. Again, Alexandra Willingham from the Center for Reproductive Rights for the plaintiffs. Defendants have moved for relief that is typically sought when a defendant raises jurisdictional defenses for the first time and prior to discovery. Defendants failed to show, either in their motion or before this court today, good cause to stay discovery now. I was listening very carefully to what the other side had to say, and I did not hear how the new amendment to the medical necessity exception actually changes the landscape on the ground for pregnant Tennesseans and the physicians who treat them, or how defendants meet their burden of establishing why this court should revisit its decisions on sovereign immunity and other defenses, or any examples of how the new amendment changes the scope of discovery in any material way. Given the unusual posture of defendants' motion to stay, it is incumbent upon defendants to concretely show why a stay of discovery is warranted. The omissions I have just listed highlight how defendants have failed to meet that burden. Plaintiff's position is that the amendment's minor change to the medical necessity exception does not merit staying discovery, and to do so would necessarily delay the scheduled trial, severely prejudicing plaintiffs. I have two main points. First, the amendment does not materially alter the medical necessity exception, so it does not moot plaintiffs' claims. In your order on defendants' prior Rule 12 motion, you sustained plaintiffs' claims for declaratory relief, for pregnant Tennesseans' rights to life and equal protection, and for unconstitutional vagueness. These claims remain before you with an additional plaintiff, the AMA, and an additional equal protection claim regarding the ban on abortion care for life or health-threatening mental health conditions in pregnancy. To merit a stay of discovery now, defendants have to show you that the recent amendment changes your prior ruling, and they have not done that, and they cannot, because the amendment does not alter plaintiffs' claims. An amendment only moots a case if it clearly cures the alleged defect or otherwise changes the law so that plaintiff's complaint no longer applies or is otherwise transformed. As we will address further in our response to defendants' Rule 12 motion, defendants have failed to establish that any of those circumstances are true here. The amendment does two things. It defines serious risk of substantial and irreversible impairment of a major bodily function using substantial and irreversible impairment of a major bodily function. And it identifies as conditions that may fall within the medical necessity exception. The conditions this court has already held do fall within the exception. I did not hear from my friend on the other side a concrete explanation how these changes actually alter the substance of the medical necessity exception. Thus, this court's holding in its temporary injunction order remains true. The issue of which conditions and the timing of when they present and escalate to life-threatening conditions constitute medical emergencies within the medical necessity exception is demonstrably unclear. To get into the specifics of defendants' failure to explain how the amendment eliminates the legal defects with Tennessee's abortion ban, we identified in our complaint 4 problems with the ban, and the amendment only addresses one of those problems and not in a meaningful way. Specifically, we plead that substantial and irreversible impairment and major bodily function are vague by themselves and in combination. Defendants do not explain how the circular definition in the new amendment, which does not define these terms, solves that vagueness. Moreover, defendants do not explain how the definition clarifies when abortion care can be provided. We plead that reasonable medical judgment in a criminal case risking 15 years in prison chills abortion care. Defendants again do not explain how the amendment resolves physicians' concerns. And we plead that physicians do not know when pregnancy complications meet the threshold of serious risk of substantial and irreversible impairment of a major bodily function. While defendants say the amendment clarifies this question, the amendment merely says that certain conditions may fall within the exception. In other words, physicians still have to determine if the condition poses a serious risk of substantial and irreversible impairment of a major bodily function. And this fact is underscored by the sponsors of the bill, who stated in the legislative record that these conditions do not automatically fall within the medical necessity exception. That second step of whether it meets the test is yet to be covered. And neither the definition nor the specified conditions provide clarity as to other conditions for which abortion may be within the standard of care. So to give this court a couple examples, the amended medical necessity exception provides no clarity for placental abruption, which is a condition that we discuss in both our complaint and in multiple of our expert reports. Placental abruption is the separation of the placenta from the uterus, which reduces nutrition to the fetus because it interrupts the blood flow and risks hemorrhage in the pregnant patient. Pre-viability, this is usually addressed with abortion care. And if this condition is not treated early, the hemorrhage occurs, hemorrhage may not be reversible and a patient may require a hysterectomy, and the fetus has been starved of essential nutrition. Another example is sickle cell disease in pregnancy, which risks multiple complications that could lead to kidney failure. This amended medical necessity exception does not address whether kidney function is a major bodily function, and whether the patient's kidneys have to already be failing, or whether a symptom such as preeclampsia that could lead to kidney failure suffices. Moreover, the complaint and the expert reports explain why treating dangerous conditions such as the ones I've just described must be done as soon as possible. Finally, I did not hear from defendants how the amendment addresses plaintiffs' equal protection claims. This court has already held that plaintiff patients are similarly situated to non-pregnant women also seeking emergency care. That patient plaintiffs have sufficiently pleaded that Tennessee's abortion ban discriminates against them by banning the emergency care they need, and that this unequal access is not reasonably related to a legitimate state interest. I have heard nothing from defendants about how the amendment alters any of these components. In sum, the changes wrought by the amendment are insubstantial, and the amended abortion ban still disadvantages plaintiffs in the same fundamental way. And as a result, there is no reason defendants cannot or should not proceed with discovery during the pendency of their motion. As an initial point, the fact that defendants made a dispositive motion during discovery does not entitle defendants to a stay. It is the practice of courts around the country to require more than the pendency of a motion to stay ongoing discovery. Defendants have cited no authority to the contrary. In fact, the numerous authorities that defendants say they have cited all involve immunity questions being raised and substantively addressed for the first time. Practically speaking, defendants have sufficient notice of plaintiffs' claims to continue with discovery. Because the amendment does not materially affect plaintiffs' claims, defendants are in the same position as to plaintiffs' claims as they were when they filed their answer to this complaint. And arguably, they're actually in a better position to understand plaintiffs' claims because plaintiffs have filed their expert disclosures. 3 of our expert witnesses discuss in detail the confusion caused by Tennessee's abortion ban. And this is as it should be. Tennessee, as a notice pleading state, anticipates that the key details about plaintiff's claims will be revealed and probed during discovery. And indeed, it has always been clear in this case that it would be fact-heavy and require significant discovery. Plaintiff's claims focus on how Tennessee's abortion ban and its medical necessity exception affect physicians and patients on the ground. These are fact-intensive questions. On page 4 of their opening brief, defendants list questions they have about plaintiff's claims post-amendment. But these questions are precisely the kind of questions one asks during discovery to test the strength of plaintiff's claims. If the expert reports do not answer these questions, defendants can ask plaintiffs and the experts about the amendment in depositions, which they have still not noticed. It is incumbent on defendants to show why the new amendment changes discovery, but defendants have provided no relevant examples of how the scope of discovery has changed. The question for defendants in the discovery disputes they cite, such as Ashcroft v. Iqbal, is how defendants' production burden changes. But here, defendants' production burden hasn't changed. We haven't changed our requests. Rather, defendants have flipped the usual inquiry, and they're speculating about how discovery from us will change, which is in defendants' control as the ones promulgating the requests. But more important, defendants' defenses to discovery haven't changed. Their objections to our document requests cite defenses like deliberative immunity, and deliberative immunity is not affected by the recent amendment. Additionally, defendants' claim of burden on public servants is also not good cause for a stay here. Defendants have not submitted a declaration describing the specific burdens on the public servants that they reference, nor have they submitted a Rule 26 motion for a protective order, which would have been the appropriate remedy if the burden was so onerous. Additionally, defendants cannot justify a stay by raising immunity and justiciability theories this court has already heard and rejected. This court has already ruled that sovereign immunity is waived as to our claims and that these claims are justiciable. Defendants have failed to show this court how this amendment changes those rulings. And defendants' attempt to get a second bite of the apple is not good cause to stay discovery. While we will more fulsomely brief the issue of sovereign immunity in our response to the Rule 12 motion, a brief discussion, now of Section 13121 is necessary to explain why defendants' revived sovereign immunity defense is not necessary to stay discovery. Defendants are once again making a facial challenge to the court's subject matter jurisdiction. This court has already rejected such a facial challenge. As the facts pleaded in the complaint are virtually the same, there is no reason for a different result now. This court already ruled that sovereign immunity is waived under 13121 and the Colonial Pipeline exception. Defendants do not even try to explain how the amendment changes the court's sovereign immunity analysis, nor could they when the amendment says nothing about sovereign immunity, it does not modify Section 13121, nor does anything in the text of the amendment support that plaintiffs are no longer affected persons for the purposes of that statute. This court has already found sufficient patient plaintiffs' pleadings that they fear the inability to obtain medically necessary abortion care in Tennessee in the future. The amendment does not eliminate that fear. This court has also already found sufficient physician plaintiffs' pleadings that they no longer provide abortion care that they provided prior to the ban, and that physicians fear they will be criminally prosecuted or disciplined for providing abortion care. Again, the amendment does not eliminate those fears. Additionally, nothing in the text of the amendment supports defendants' suggestion that there is no longer an adverse governmental action for the purposes of 13121. This court has already found that there is sufficient governmental action for the purposes of that section because none of plaintiffs' claims would be asserted but for the enactment of Tennessee's abortion ban, and because physicians have stopped providing necessary abortion care out of fear caused by the passage of the ban. Both remain true after the amendment. We are still under Tennessee's abortion ban. Rather, defendants appear to be arguing that the second amended complaint instead allows them to revive their sovereign immunity defense. But this argument relies on an incorrect construction of Section 13121. Plaintiffs state in their second amended complaint that sovereign immunity is waived under this section. No more is required, and stating a claim under the section is certainly not. Plaintiffs have pleaded constitutional claims that existed long before 2018, which is when Section 13121 was enacted. This section therefore clearly recognizes a waiver of sovereign immunity for constitutional claims not seeking money damages. This section does not create constitutional claims. And this reading is consonant with the Tennessee Supreme Court's interpretation. The weakness of defendants' contrary construction is underscored by their reliance on one authority, Traumed, which is a decision about notice pleading, which was rendered 16 years before Section 13121 was enacted, and is thus utterly inapposite. Defendants also failed to articulate a concrete reason why the Colonial Pipeline exception to sovereign immunity no longer applies here. This court has already held that plaintiffs adequately allege that defendants are enforcing an unconstitutional law and plaintiffs are affected parties. The proper time for defendants to raise these arguments is through a motion for summary judgment at the close of discovery. This is the path that was contemplated and agreed upon in the scheduling order. Turning to my second point, plaintiffs and judicial economy would be greatly prejudiced by a stay. Plaintiffs filed this case in September 2023. And as this court has already pointed out, trial is scheduled for April 27th, 2026. As defendants have conceded, if we delay discovery, we will lose this trial date. And plaintiffs need a final judgment to clarify the safety of being pregnant and the availability of medically necessary care in Tennessee. Patient plaintiffs continue to plan their lives amid uncertainty over how Tennessee's laws would impact their access to medically necessary care. Plaintiffs remain of reproductive age, and many want more children. Each patient plaintiff fears becoming pregnant again in Tennessee or questions their ability to get medically necessary abortion care if needed. Meanwhile, the physician plaintiffs and other AMA members fear criminal prosecution and civil penalties for providing life and health-preserving abortion care they regularly provided to their patients before the abortion ban took effect. The temporary injunction only protects physician plaintiffs from threats of discipline for providing abortion care in some instances, not in every circumstance where abortion care is medically indicated under the standard of care. This uncertainty can only be resolved through final judgment, but a stay of discovery would almost certainly delay that final judgment. Also, at this point in discovery, a stay would be particularly unfair to plaintiffs and would prejudice plaintiffs' trial preparation. Plaintiffs have disclosed their experts and have produced thousands of documents. Meanwhile, defendants have produced 18 unique documents. The thousands of documents they cited from the governor's office was the result of a third-party subpoena, not defendants' direct production, and they are also only constituent letters that mention abortion in any context. Defendants told us months ago that they were reviewing emails, as they have mentioned again today, but we have not seen a single one of those emails. A stay would extend defendants' deadline to disclose their experts, delay defendants having to account for significant deficiencies in their discovery responses, and force plaintiffs to duplicate their current negotiation efforts when the stay is lifted. So contrary to defendants' assertions, plaintiffs' claims remain viable after the recent amendment to Tennessee's abortion ban, and discovery remains relevant and necessary. Defendants' complaints of the ordinary burdens of discovery and their attempts to recycle already rejected arguments do not merit a stay of discovery. I welcome the court's questions, and we request the motion to stay discovery be denied.
This panel member does not have any questions at this time. Judge Donaghy, do you have any questions?
I have no questions.
All right. Chancellor Colbert.
None for me for today.
All right. Just as a gentle reminder, I guess I have one comment that I would just like to remind all of the parties at this point is this court's temporary injunction was just that. It was a temporary injunction. No findings were made that are permanent. And so a temporary injunction speaks to the matters during the pendency of the case and is not final in any manner. And I know references have been made to, as this court found in its temporary injunction, and that is correct. But all of those matters remain subject to revision and further proceedings in the case. So just a gentle reminder on the temporary nature of the temporary injunction that is in place. All right. General Griffin, would you like a rebuttal?
Just very briefly, Your Honor, if I may.
Please proceed.
Thank you. Virtually all the arguments from my friend on the other side had to do with why this court should deny the defendant's pending Rule 12 motion for judgment on the pleadings, and not particularly why a stay is warranted given the jurisdictional challenges. In fact, my friend's arguments essentially asked this court to deny the stay because it has jurisdiction. But we've raised jurisdictional challenges. This isn't the place necessarily for the court to get into the weeds on all of those. The mere fact that we have raised those challenges is sufficient. But if the court were to take the plaintiff's arguments, it would essentially deny the stay based on a lack of jurisdiction. We think that would be unfairly prejudicial to the defendants in this case. I did hear one thing about this being an unusual posture, but the only unusual thing about the current posture of this case is that the statute that the plaintiffs have challenged has been amended, but the plaintiffs didn't amend their complaint. The typical course when a challenge statute is amended is that you either amend your complaint or the case gets dismissed. And the plaintiffs here have chosen not to amend their complaint. They say the court has jurisdiction and that discovery should proceed, even though no plaintiff in this case has asserted any claim that the current statute is vague or unclear. Not a single plaintiff has asserted a claim that the current statute prevents them from obtaining any medically necessary abortion. Not a single plaintiff in this case has asserted a claim that there is a threat of enforcement under the current statute against them by any defendant. The court hasn't yet had an opportunity to address any of those claims. My friend on the other side also said that the amendment to the statute is insubstantial. And of course, they're free to make all those arguments in response to our motion for judgment on the pleadings. They could have made those arguments in an amended complaint, but they didn't. But I just wanted to address that really fast before we close. The statute as it currently stands in Tennessee now uses almost the exact same language verbatim as the Pennsylvania statute that the Supreme Court addressed in Planned Parenthood versus Casey. Under the Supreme Court said satisfied the undue burden standard, which is a form of heightened scrutiny. That Pennsylvania statute, just like Tennessee statute now, permitted abortions if the mother had a condition that, quote, so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will create serious risk of substantial and irreversible impairment of a major bodily function. That's almost verbatim the exact language of Tennessee's current statute that the Supreme Court approved at that time. And in Casey, the district court narrowly construed the statute to include conditions like preeclampsia and inevitable abortion and PPROM. But the Supreme Court agreed with the Court of Appeals in that case that under some circumstances, each of these conditions could lead to an illness with substantial and irreversible consequences. And so to the extent that today's Tennessee statute says that those conditions may present a serious risk, that's consistent with the same statute that the Supreme Court in Casey said satisfied a heightened scrutiny standard. In fact, Tennessee statute today even goes beyond that one because it actually includes definitions and examples of medical conditions that would qualify under the medical exception. And the statute approved by the Supreme Court in Casey didn't even do that. Of course, all that being said, the court has not yet addressed any of plaintiff's claims in the operative complaint as it pertains to the new statute. We think our jurisdictional challenges are especially relevant, especially given that the defendants in this case are government officials, public servants. And so for all those reasons, we think it would be unfairly prejudicial to require that this case goes forward before the court has an opportunity to adjudicate the jurisdictional challenges we've raised. Happy to answer any additional questions the court may have.
This panel member does not have any additional questions. Judge Donaghy,
I have no additional questions.
Chancellor Colbert.
None from me.
All right, before we adjourn this hearing, that concludes the argument on defendant's motion to stay, but I would like to briefly confer with the parties regarding a hearing date on the motion to dismiss. We had previously offered, I think, 2 dates. Correct me if I'm wrong. July 25th and August 8th. And as you, I hope, can appreciate, the panel members' schedules are constantly changing with other court matters, and we're doing our best to coordinate and hold dates in reserve for this case, but we have had a conflict arise with the July 25th date. And so I would like to hear from both sides as to availability to move the hearing date to August the 8th. And if you need to confer about that and get back to the court with your response, we're of course happy for you to do so. But I wanted to address that today while you were all present and see if we could make August the 8th work. And I would also ask the parties to consider, while our preference is generally in person, if it is more feasible for you all to appear by Zoom to present argument, since it's not an evidentiary hearing, please let us know what your preference is on that in terms of travel schedules and so forth, because I know that can be a constraint as well. So would you like to speak to that now, or would you like to have the opportunity to confer? And we would ask that you communicate your response back through the law fellow who has been assigned to this case from the Administrative Office of the Courts, who is Duncan Bryant, and he's on this Zoom hearing, so he can be anticipating your call back if that's what you need. I'll turn to the plaintiffs first. Do you have a response to the August 8th date, or do you need to confer?
We are not available on the August 8th date, so we would request an alternative date.
Well, that makes for a short discussion then on that issue. So we will provide some additional available dates to Mr. Bryant, and he will circulate those to both plaintiffs' counsel and defendants' counsel, and we'll have to proceed from there. We understand the urgency of addressing this as quickly as possible, so we will do our best to find a date as quickly as we can. Do you have anything to add, General Griffin?
Your Honor, the only thing that I would add is that when we initially filed our motion to stay discovery pending a ruling on the Rule 12 motion, we asked for expedited consideration of the motion, and it was denied because the court was unavailable to hear it on an expedited basis. But we would, given the posture of the case and the circumstances involved in the nature of the defenses, we would ask or reassert our request for expedited consideration of the stay motion.
Well, we're doing our best to try and schedule it as quickly as we can. And, you know, I certainly hope the counsel for the parties appreciates the fact that each of the 3 courts have longstanding matters on our calendars, and we're doing our best to accommodate the needs of this case as well. It's a tough balancing act at times. So we are doing our best to make ourselves available to you all. We will provide some additional dates, as I said, to Mr. Bryant, and he will circulate those among counsel. And if you could respond to Mr. Bryant at your earliest opportunity, we would appreciate that.
Thank you, Your Honor. I just want to make clear when the court may have misunderstood, and I was asking for expedited consideration, not of the Rule 12 motion, but of the stay motion that we've argued here today, asking the court to pause discovery until it has a chance to rule on the dispositive motion. We just asked for expedited consideration of the motion that we have argued today.
Well, because of our schedules, we are unable to issue a ruling following this hearing. We're going to have to confer and issue it as quickly as we can. It will be in writing and it'll be distributed to the parties so that you can proceed accordingly. And my best estimate is that we will have it, have our ruling out next week, but we've all got matters that are requiring our time. So we're going to confer and get our ruling out as quickly as we can.
Thank you, Your Honor.
All right. Is there anything else from plaintiff's counsel before we adjourn?
Nothing from plaintiffs. Thank you, Your Honor.
All right. Anything else from defendant's counsel before we adjourn?
Nothing further, Your Honor. Thank you.
All right. Thank you all for being present today. That concludes our hearing on defendant's motion to stay.